Right, here we are. Here's my message. Thank you. Well, good morning, everybody, and welcome to our licensing committee. And it's so nice to see so many of us here this morning, rather than just the usual team of three that we have when we actually do a hearing. So I hope you're all keeping well, and I hope you're all busy, and I hope you're all keeping safe as well. We have a formal agenda this morning, and it's to discuss our licensing policy. This has been under review for a period of time now, with the out to consultation. I'm sure Sarah will explain to us what has been happening. You have the document in front of you, or you've printed it off, and the amendments or the variations have been in grade, so you can see where the additions or the deletions are. So I'm going to move to item 1 on the agenda, which is to receive any declarations of interest, please. Are there any? I'm looking around. I don't see anybody indicating.
No.
I'm not using the chat bar this morning. I am. If you wish to speak, could you raise your hand, please? Because I'm watching everybody on the screen. Thank you. I'm sure that others will be using the chat bar, and if the officers see that, perhaps they can advise accordingly. Thank you. So no declarations. So apologies. Now this is going to be a difficult area because I know that some people are missing from this meeting. They may well join later. We haven't had any apologies, have we?
Would you like to go for a roll call just to confirm people's attendance as well?
Well, I had a look to see who's about, and it's more about those who haven't attended. Obviously, I've got Councillor Adams, Councillor Catchpole, Councillor Fulger, myself, Councillor Harrison, Councillor Caroline Kirami Guavalu. I'm sorry, I do apologise for that. Councillor Kelly, Councillor King, and then the 4 at the bottom at the moment. That's Leggett, Murrell, Shaw and Thomas. I don't think we've had anything from, have we? No. So we'll report them as missing, shall we? Without apology. Thank you. So with that, we'll move on to item 3, which is obviously a review of the licensing policy. And I'm going to ask Sarah Harris, our licensing officer, to present the paper and her report. Thank you.
Thank you, Chairman. So in summary then, this report details the outcome of the consultation process in respect of the review of the licensing policy and makes recommendations. In terms of background, the Licensing Act 2003 requires each authority to carry out its various licensing functions so as to promote the 4 licensing objectives. And these are the prevention of crime and disorder, public safety, the prevention of public nuisance, and the protection of children from harm. In order to achieve these objectives, the authority is required to publish a statement of licensing policy which sets out the policies the authority will generally apply to promote the licensing objectives when making decisions on applications made under the Act. The policy should be agreed by full council. The Act requires the licensing policy to be reviewed every 5 years. The authority's current licensing policy expires on the 6th of January 2021, and the new policy must therefore take effect from the 7th of January 2021 for a further period of 5 years. Moving to the issues, the policy document, which is attached as Appendix 1 of your report, which is on page 9, has been circulated widely to stakeholders throughout the Broadland district, as well as to numerous national, regional and local representative bodies and organisations, with a closing date for comments of the 21st of September 2020. 501 individuals and organisations were contacted in writing to advise them of the policy review. Copies of the policy were available at local libraries, and hard copies could be requested by contacting the licensing office. The document was also posted on the Council's website for the full consultation period. Central government published a consultation code of practice in July 2008. The code recommends that responses to consultation exercises should be analysed carefully. The focus should be on the evidence given by consultees to back up their arguments. Analysing consultation responses is primarily a qualitative rather than a quantitative exercise. Following a consultation exercise, a summary of who responded to the consultation exercise should be provided, along with a summary of the views expressed to each question. A summary of any other significant comments should also be provided. The purpose is, in the event that an authority's policy is challenged, the authority could demonstrate to a court how it arrived at its policy and that due weight and consideration have been given to all representations, including, where appropriate, why some had been disregarded. Given the relatively small number of responses received to the consultation, the responses have been set out in the following format. The responses are attached to Appendix 2 of the report, which is on page 39. As you can see, there were only 2 responses to the consultation. But the format used in setting those out is a reference number for each representation, the name of the respondent, a summary of the respondent's comments, the authority's appraisal of the comments, and the authority's response. Further guidance recommends that any amendments made to the licensing policy during the course of the committee meeting should be carefully and accurately recorded with well articulated and reasoned details. Appendix 3, which is on page 41 of your report, details the main amendments to the policy document. Those amendments which were proposed at the start of the consultation period are highlighted in yellow in the copy of the policy you have in the report. And the section highlighted in 6.1 of the policy document is the proposed change as a result of a response received during the consultation process, but that is the only proposed amendment at the moment following the full consultation process. Considerable partnership working and liaison with all Norfolk authorities and statutory bodies has taken place in respect of the enforcement of the Licensing Act 2003, essentially to provide for consistency of approach. As a result, a joint enforcement guide was produced, which is attached to Appendix 4, and it is recommended that this document forms an annex to the licensing policy document. In terms of proposed action, the committee is requested to thoroughly review and consider Appendix 2, which details the responses to the consultation process. Moving on to issues and risks. In terms of resource implications, there are no specific resource implications in respect of the review of the licensing policy, other than those already identified and funded to enable the authority to comply with the overall requirements of the legislation. The level of income generated by and arising from the implementation and enforcement of the Licensing Act 2003 will be kept under close review. Legal implications. The Licensing Act 2003 requires the authority to produce a statement of licensing policy, to consult in respect of the policy, and to have discussed and formally adopted the policy by the 7th of January 2021. An equality impact assessment has been completed with no issues or concerns highlighted. There are no human rights issues specific to the licensing policy, providing the authority can demonstrate best practice and compliance with national guidance in production of the policy. In making their determination, committee is requested to ensure that the principles of the prevention of public nuisance licensing objective are upheld, and in terms of crime and disorder, in making their determination, committee is requested to ensure that the principles of the prevention of crime and disorder licensing objective are upheld. Moving finally to recommendations, the committee is recommended to consider the amended licensing policy, the proposed amendments which are highlighted, and the schedule of responses received as a result of the consultation in respect of the review of the licensing policy, and make any necessary decisions, and refer the amended licensing policy together with any recommendations to Council for its formal adoption. So that's the report. Thank you, Chairman.
Thank you. I have been through this, and I have read it at its consultation stage, and I know that I sent it to the portfolio holder responsible for licensing, Councillor Leggett, and she had some comments that she made. They're not listed here. Can I be assured that her comments were considered and, if necessary, fed into the policy document, please?
Yes, of course. Yes. So both yourself and Councillor Leggett were informally consulted on the policy document before it went out for formal consultation. And you're correct that Councillor Leggett forwarded some comments as a result of that, and those were incorporated into the policy document before it then went out for the formal consultation. So they're not highlighted here, but they have been incorporated into the document.
Yeah. Because I find it incredibly sad that we sent out 501 letters, consultation letters to our policy, and we got 2 back. I find that quite sad. I'm not going to expand on it. Well, pathetic, but you know, is it that our policy is so good that people don't need to comment on it, or is it that they just don't bother? It is concerning.
Yeah, I mean, I guess this isn't a significant change to the previous policy document. It is a review which we're required to do, but in terms of the content, it's mainly an update in terms of legislative and guidance changes. So it's not a particularly contentious review, I guess, which might explain the limited number of responses. But obviously, it's difficult to predict completely what the reason might be for that.
Yeah, I'm always very worried, and I was the other day with a hearing we had, that there's nothing coming back from child protection or safeguarding, and I do think that is something that I might well take up in another guise at county, because I do think it's very important when we're dealing with this particular like of licensing, that we do have some comment back from child safeguarding and public safeguarding. So I will be writing to the county officer about this, because I think they should be responding. We don't ask them very often, and I do think they should respond. So I'm going to move to our solicitor now. Hello, David.
Good morning, Chairman. Am I coming through okay?
Yes, lovely. At the moment, we don't want to lose you like we did the other day, but good morning to you. I hope you're well. Do you want to add anything here at this stage, please?
Yeah, thank you. That's helpful. I've got a slightly dodgy internet connection, so what I'm going to do is take off the video, as that will hopefully help. I think that would be sensible, but obviously the audio continues.
Yes.
Just on a couple of the points you raised, we never hear from child protection or safeguarding. I can't remember the last time they wrote in, and I've been doing the job for a remarkable number of years. The local policy cannot conflict with national policy, and I think therefore a lot of people who receive the draft will think, I already know what's in it, because they might be fully conversant with the Section 182 national guidance. There are a couple of matters to flag on paragraph 2.19 petitions. Just find the thing. This is really agenda papers 14 and 15 on my copy, pages 6 and 7 printed on the policy draft itself. And the reason I'm flagging a bit of concern is para 2.19, where the council says, unless you jump through these hoops, we may not count it as a relevant representation. And we expect the lead signatory to be contacting everybody else on the petition. And I'm just to flag, I don't think that is something you can demand the lead signatory to do. The obligation on the council is to write to everybody who's made a relevant representation, letting them know of the forthcoming hearing. So unfortunately, I can see there's a very good administrative reason for it, but I don't think it can be, as it were, delegated to the lead signatory. And the definition of relevant representation is in the Act. It's not something really within the discretion of the council. And that's the last sentence of 219 on page 15, where it says, petitions not received by the licensing authority in this format are unlikely to be classed as a relevant representation. And that's problematic. As I say, the definition is in statute rather than the local licensing policy. And the definition in summary is somebody writes in with the right, within the right period, referring to the application and one or more of the licensing objectives and its effect on one or more of the licensing objectives.
Right, so that we need to really change that quite drastically, don't we, to get it to correlate with the current legislation. So what do you suggest, David, then we add or delete to 2.19, please?
I think the first bullet point is good.
Yeah.
And I'm on page 14 here.
Yeah.
The second bullet point is good.
Yeah.
You might want to reword it to the effect of the application on one or more of the licensing objectives. It's not bad as it stands.
Right.
Each page to include information as to the purpose of the petition. That might be sensibly reworded to giving a statement about the licensing objective and the concern, because I don't want them on page 3 basically rewriting so it's no longer clear what someone's signing.
Right.
Fourth bullet point's good. Fifth bullet point's good. The sixth bullet point, fair enough. I would personally delete the seventh bullet point, and we're now on page 15, because I think we're in trouble saying we will not contact each signatory. And I would lose the, no, I beg your pardon, eighth bullet point is good. But that last sentence, I think, has to go.
What, the petitions not received by the licence authority in this format are unlikely to be. Yeah.
Yes.
Yeah. I think any petition that has names and is valid is worthy, is acceptable.
Mm-hmm.
So
and it may well count as a relevant representation, however they decide to put it together.
As long as it's not full of Mickey Mouse and.
Well, I mean, you'll ignore Mr. Mouse and Minnie Mouse, but unfortunately, it does put your officers through a great deal of work. But I don't think there's an alternative to it.
Right. So, did you get that, councillors? Please.
Yes, Chairman. Can I just add a point here?
Yes.
Are we accepting the fact that the amendments will be done, or is this going to be represented to us at some stage where reworded?
I think if we voted them through this morning as amendments, they will be done.
Okay, thank you, Chairman.
Yeah, you'll be recommending these amendments to full council. The policy will go to full council to be determined.
It will go to full council. I'm not sure if we have the power to remove them or not.
I would say you certainly have the power to make recommendations.
Yeah.
That's the purpose of this meeting, is to look at your draft policy and the responses to the consultation.
Yeah. Tony. Can you unmute, please?
Yeah, here we go. Yeah, I'm still a little bit, I understand what David is saying in relation to bullet point number 3. I'm not quite sure as to what we are saying in terms of the wording, Chairman. Because for the greatest respect, David, he said roughly why we need to reword it.
Yeah, my apologies. I think I was waffling a bit at that point.
No, not at all, so, David. I think we need to be precise on what the wording should be. Yeah.
David, can you give us wording for that one, please? In legal.
Yes.
Legal. Thank you.
I think this would be good wording. Each page must include a relevant representation.
And then carry on as to the purpose of the petition.
No, I think a relevant representation would do the job nicely.
What, full stop and then delete everything after it? So we delete as to the purpose of the petition so it is clear?
Yep.
Yeah,
because if it counts as a relevant representation, that means it must be in respect of this application and the possible effect on one or more of the licensee objectives. And you wouldn't have to, as it were, specify it twice.
So our recommendation, councillors, for bullet point 3 is, I will read it. Each page must include a relevant representation, full stop, and then delete everything else. Now, have I made that clear, please?
Yes.
Yeah. Yes. Okay. And you're all happy with that, please, given the legal advice we've been given? Yeah. Okay. Right. Okay. And then we're going to delete. Now, David, I'm not sure about the last bullet point on page 14. I've got a ring around that. Are we deleting that? That's the first name respondent is taken to be the instigator of the petition.
No, I couldn't see anything wrong with that,
that's okay,
Chairman.
So the other one is that we delete the next one, which is at the top of page 15 in its entirety.
Yep.
The second bullet point on page 15 remains as is.
Yep.
And then we delete the sentence underneath that says petitions not received by the licensing authority in this format, etc. That's deleted. So these are the recommendations to council. Is that right, Linda?
Yep.
Yeah.
That's right.
Yes. So I'm going to propose that these are the recommendations to council in view of so far as we've got to the agenda and the document.
We've got another comment on a further paragraph, Chairman.
Yeah.
Just the one.
Is that on the same page, or is it a different piece of the work?
It's paragraph 2.7 on page 12.
Right. Okay. Well, let's deal with this one first and get this one out of the way. So I'm going to propose that on page 14, 2.19, we make those recommendations to the council, and on page 15 likewise. So can I have a seconder, please?
Me, I'll second, Chairman.
Yeah. Right. So are we all in agreement, please?
Yes.
Yes.
Yes. Okay. So am I. So we've dealt with that one. That will go to full council. So we'll go back to page 12. And David, you've got one on there, please. Thank you.
Very short, Chairman. At the moment, it says conditions may be imposed on a licence following relevant representations received from responsible authorities. That's perfectly true. But of course, you can impose them following representation received from anybody.
Can you repeat the last bit, because we lost your voice? No, we've lost.
Yes, it's a really tiresome connection.
Yeah.
Am I coming through okay now?
Yes, at the moment, yes.
Lovely. So as you can impose conditions following relevant representations, whether received from responsible authorities or not, I think if the sentence read, conditions may be imposed on a license following the receipt of relevant representations, full stop.
Yeah.
It would be a bit clearer.
Yeah, because at the moment we're narrowing it down to just one particular group, whereas it can be
read by implication. Yes.
Yes. Okay. So there's a change there. I'll propose that goes to council as well. Can I have a seconder, please?
Yes, I'll second it.
And are you all in agreement, everybody?
It simplifies it, yes.
Yes, I'm looking around. Everybody's happy with that. Right, David, are there any more in the document, please?
Not that I've found, Chairman. So
right.
That's the end from me at the moment.
Lovely, thank you. Right, over to you, councillors then. I take it that you've had a good look at this document. So has anybody got any comments or any amendments? Yes, Caroline, thank you.
I was a bit concerned about 7.11. it says where entertainment requiring a licence is specifically presented for children, the licensing authority will require the presence of an appropriate number of adult staff. Now that's been crossed out. And I just wondered why we were removing adult supervision, just for safeguarding purposes.
Can you say which page it's on, please?
It's on page 22.
22.
7.11.
Right. Yes, right. Okay, Sarah.
Yes, thank you. I think the reason for removing those, each of those points, was that they were quite specific in terms of we would be recommending an appropriate number of staff, and I don't know that it's necessarily our position as the licensing authority to specify a number of staff, but we would be looking at an overall approach to the application to make sure that obviously that children were going to be protected and weren't going to be put in harm's way unnecessarily. So rather than specifying numbers, we would be looking at a more holistic approach to the application and what they are intending to do to ensure that children were protected in that situation. So we didn't see a need to have that specific condition included in the policy.
Sarah, could I suggest we just delete number out of that and just put will require the presence of appropriate adult staff to ensure public safety and their protection from harm?
Yes, we could. If you would like to make that amendment, we could do that. We could retain that paragraph and just make that minor change. That would be fine.
Yeah, I think we do need that. We need to show that, you know, we are specifically looking after the children, and we need to have something in there that actually specifies that, and I agree with Caroline.
Can I propose that, Sheila?
Yes, I'm just going to ask Sarah a question, which is, currently, what would we be doing? Would we be specifying the number of adults per ratio to children?
We don't currently know. The applicant might volunteer a number as part of their application, but I guess unless the application went to committee and committee were particularly concerned and wanted to attach a condition that specified a ratio, we wouldn't ordinarily, but so it would be, and it's not something we've done in the past, but it is an option, I guess, that would be open to committee if they wanted to do that in terms of a particular application.
So, for instance, you could, if it went to committee, the committee could say, well, it's 1 adult to 5 children. That sort of thing.
Yeah, I mean, I don't think we've had many applications that fall under this category where we've had any particular concerns of this nature. But obviously, if they did come up, then it is something that we could incorporate into any granted license. That would be perfectly reasonable.
So just give me an example of entertainment for children that would require a license then. Please.
Well, if we had an application for a theatre, I suppose, if we had a theatre on the district and they wanted to apply for a license for shows, they might be specifically for children, then that's something we might want to consider. But we haven't really got any of those kind of premises on the district at the moment. But specific sort of drama and theatre type premises, we don't really have anything like that at present.
So it would be mainly related to that part of the entertainment industry then.
Yes, yeah, I would.
Sheila, can I mention something?
Yes, thank you.
Under that section, under children and public entertainment, 7.16, it says the authority recognises that vulnerable persons can also include adults. So adults might be present at children's public entertainments, which are vulnerable, and they might be purchasing alcohol.
Yes, Sarah.
Yeah, I mean, I think it's more recognising that the preceding paragraphs could apply to vulnerable adults as well as children. So obviously we need to have certain measures in place to ensure the protection of children from harm. But I think we're just recognising in that sentence that vulnerable adults may potentially need similar protections in place.
Right, thank you. I know Mr. Leggett's joined us. Can we note in the minutes he's joined us at 10 o'clock? I don't know what happened to him at 9:30, but he's here now. Okay, so we've got a proposal then on page 22 to delete under 7.
Sorry, good morning, Chairman. I'm sorry I'm late. I've had problems with my computer.
Okay, thank you. We are sort of well into the meeting now.
Yes.
Mr. Leggett, yes. Okay, so we've got a proposal from 711. Caroline has asked to delete the word number. Appropriate, presence of appropriate adult number of goes. So that's reads if these have got a line through them, Sarah, does this mean you want them lifted?
The proposal was that they would be removed from the current policy document, but obviously if committee would prefer that they remain, then that's within your...
That's what I'm saying, Sheila. I prefer it to be included in the policy.
Yeah,
but just
that's fine. But what about 712 and 713? Do you want them left as well, please?
I don't think we need to, but just that I'm just concerned that the safeguarding of children, really, that adult staff should be there to protect them. We don't need to quote the number, but
yeah, Chairman, I'm just wondering about what can be classed as appropriate, and whether that could be, somebody say, well, we think it's appropriate. Who makes the determination? We as the licensing?
Sarah.
Yes,
it could be challenged.
Well, it's got. Sorry, would you mind if I address committee, Chairman?
No, but I've just got. If you just hang on, I've just got David King, who I know wanted to say something. So if I just take David first, and then David King first, and then David the solicitor after that.
So my question was pretty much the same as Ken's. I'm just concerned that if you're going to dictate that you have to use the appropriate number of adults, which set of guidance do you use? Do you use the NSPCC's guidance? Do you use Norfolk County Council's guidance, or who decides what set of guidance to actually use? I think that could potentially be very, very cumbersome, and it's also in other legislation as well. The licensing officers know what they're doing when it comes to issuing licenses, and I honestly don't feel that unless, because it could create just another layer of interference when something could be relatively simple to do. Child safeguarding is very important, but the Licensing Act 2003. The child protection aspects are different to adult supervision of those children. And I don't think it's the licensing officer's responsibility necessarily to dictate on how many adults are going to look after children. I don't think it's their job.
Right, thank you. David.
I was going to respond to, as it were, the comment before, Chairman, that it would be the choice of the committee, advised by officers as to what you were considering as to the word appropriate. So if you were minded to retain those paragraphs, they do already, the wording already has a reasonable amount of discretion in it. The appropriate number could be 0. Unlikely, but possible.
So, David, in your opinion then, do we reinstate 7, 11, 12 and 13, or as David King says in the rest of the policy and the children's safeguarding policy 2003, that already covers a lot of it?
I would say 712 is legal boilerplate and nobody is the worse off if it's there. It is indeed proper to expect operating schedules to competently deal with the question of children and the licensing matters.
Okay.
713 again, legal boilerplate, no offence matters there. 711, it depends on whether you wish to retain that, and if you are concerned that it may cause an unnecessary layer of bureaucratic tiresomeness, you could replace will with may on the second line.
Yeah. And what about the deletion of the number of adult?
My own view is that an appropriate number already has an adequate amount of discretion and flexibility in it.
So you're suggesting that we keep that as it is then?
If the view of committee is you wish a decent amount of flexibility, it's already there.
Right. So Caroline,
Yeah.
taking that on board, please.
Yeah, no, I'm fine with that.
So we'll leave it as it is, but we'll change on the second line the word will to may.
Yeah, okay, and keep it in the policy. Yeah.
Tony, did you want to say something?
Only, Chairman, just to ask David, the solicitor, whether in fact 713 is really necessary when you look at 7.15, which seems to say almost exactly the same thing as 7.13.
Okay. David, solicitor.
Yes, it's legal boilerplate, sorry, it does nothing in particular that the entire licensing framework does. You could lose it and be no worse off.
Right, so 7.12 you can keep in, it's standard. Yes, it's reiterated again under 715. You can remove it.
713, yes. I mean, 713 just says you will do your job. If it wasn't there, you would still be considering attaching conditions. It doesn't enable you to attach conditions. You're going to be doing that job anyway.
So really, we could delete it and not change anything in terms of protecting children then, David?
If it's deleted, you're no worse off because you will be considering relevant representations, especially in respect of prevention of harm to children and the imposition of conditions.
So we're deleting it, is that what you're saying?
I'm sorry, I lost the connection there. It went down. I've just had to come back into the meeting.
Me too. Mine was just lost.
I think we're saying we can delete that and it wouldn't matter anyway because it's covered in law. So you don't need it in the policy because that's a duplication. So it would be fine to delete that.
Can you just say which one it was? Because I lost the connection. I've lost the meeting.
7.13.
Yes.
Is a matter of fact and a matter of law that you will do that anyway, so you wouldn't need it in the policy because it's in effect a duplication.
Right. Yeah. I'm back on board now. Yes, Sue.
Can I just come in and say I think it's really clear. So if it's a case of an applicant reading this for their own information, that sentence does read very clear. Whereas I'm not sure the 715 makes it as clear that the authority can attach conditions to licenses and prevent harm to children. That's just my view of that.
My view is that if we leave it, it's not going to do any harm to be there, is it?
Mm-hmm.
David.
Agreed.
Agreed,
Chairman.
So I'm going to propose that on page 22, 711, here we go again. The word on the second line will go to may. 7.12 will remain as it is, and we will leave 7.13 in.
Okay.
That is my proposal. Can I have a seconder for that?
Yep. Second.
Yeah.
Right. Are you all agreed?
I am.
Yes.
Yeah.
Everybody. Thank you. Right, we'll move on. Has anyone else?
Just a moment, just for sake of clarity, these at the moment are deleted. So therefore the recommendation must be, I would have thought, that in fact we reinstate 7.1 with the amendment deleted will impose may. We reintroduce 7.12 and 7.13.
Yes, Tony. Yes, that's correct. We will reinstate them. The recommendation is the reinstatement of them goes to full council.
Yeah.
With those the word amendment of will to may in the first one, 7.11. That's it. That's what we were voting on. Right. Has anybody else got any comments they wish to make on the document?
No.
No.
Nope.
I'm giving everybody a chance, please. It's important. Now is your time to raise any comments, issues, concerns over this document, because the recommendation with the amendments and the reinstatements will be that it now goes to full council for consideration and approval. Right, so Roger, can you unmute, please?
On page 70, on the equalities.
17 or 70?
70.
70. Thank you.
Equalities and communities impact assessment.
Yeah.
Yeah. Section 2, the definitions. The word we were talking about identities, etc. You've got the word sex in there. I think in current parlance that should be replaced by the word gender.
And I can feed that back to our equalities officer who puts the form together. That's not a problem.
Okay. I think it should say gender.
Okay.
Okay. What about anybody else? Any other comment on that change, please?
Fine.
So,
fine with that.
Sarah, we've got I mean, obviously it's been put together by, as you say, our equalities officer. Has this been lifted with a recognised standard form?
I'm not.
Can I come in there? There is a recognised form that's used, so we will just check those definitions are correct. But I believe that they're used for, and that's as a standard. But we will check that. Okay. And whatever is appropriate and legal, and the done thing will be put in there. Yeah, okay. that is the template that we use. So I would assume that's all correct. Okay, councillors, are we happy with that then?
Yeah.
Yeah. Okay. Right. Anything else, Roger?
No, that was one.
Yeah.
I thought stood out at the, which needed attention.
Yes. Okay. So has anybody got any more comments to make on the document? Because I'm beginning to wind the meeting up now into a recommendation. So now is your chance to speak. Everybody, Ken, you were waving your hand around. Could you unmute, please? I'm sorry, Ken, we can't hear you.
No.
That's it.
Sorry. No.
No.
Hello?
Hello.
Oh,
Hello.
sorry. I'm having big troubles. No, I agreed. I certainly agreed with what Tony Adams was saying, but I take the overall position right. And as I say, I apologise for being so late, but I have read through, and I will follow what is agreed. Obviously, thank you.
Right, thank you, David Solicitor, did you want to add any more at all?
No, thank you, Chairman.
No, thank you. And Sarah? I'm looking for Sarah. Do you want to add any more?
No, I don't have anything to add. Thank you, Chairman.
No. Okay, then. Well, I'll then move the recommendations, which are on page 8 of your agenda, please. So I think the committee has considered the licensing policy, the proposed amendments, and we have made some changes and recommendation changes, and also reinstated some of the parts of the policy that were scheduled to be removed. However, we recommend to council that they are not, and they are amended appropriately. So I'm going to propose that from the chair, that we then agree the document as amended and reinstated for recommendation to full council. Could I have a seconder, please?
Will do,
Yes,
Chairman.
Okay, so can you now raise your hands that you are in agreement, please? Right, David?
Yes, I am.
Yes,
Yes.
I am.
I can see everybody else. So that's carried. So that here is the end of our business this morning. So thank you very much for your attendance and your input. Very much appreciated. Thank you to the officers for their assistance, and to Sarah and to David, our solicitor, for attendance.